Did you know that in the United States, over half of all adults die without a will? That means most people leave their loved ones with confusion, stress, and legal uncertainty. There's a common myth that wills are only for the wealthy. But if you have personal belongings, financial accounts, minor children, or anyone you care about, you need a will. In this video, I'll explain what a will is, why it's an essential estate planning tool, what it takes to create one, and whether you need an attorney to get started. It's important to note that wills often form part of a more comprehensive estate plan, which might also include a revocable living trust, durable power of attorney, and advanced healthcare directive. They can also stand on their own. If you're interested in learning more about these other important documents, I've made more in-depth videos on each of these topics. I'll share links to those videos in the description below. A will, also known as a last will and testament, is a crucial legal document created by the testator that serves several key functions in estate planning. Primarily, it directs the distribution of an individual's assets to chosen beneficiaries, specifying who receives what from the estate. It also allows the testator to appoint an executor who is responsible for managing the estate, paying debts, and ensuring that the will's instructions are followed accurately. For parents and guardians, a will is vital for appointing guardians for minor children, ensuring that they are cared for by trusted individuals. Additionally, a will can help minimize family disputes by clearly outlining the testator's wishes, potentially easing tensions and preventing misunderstandings among relatives. Additionally, many choose to specify their wishes for charitable donations and final arrangements such as burial or cremation preferences within their will. It's important to note that a will only becomes effective after death and is subject to the probate process, wherein a court oversees the will's execution. Since probate is a public procedure, the specifics of the testator's estate will become a matter of public record, which might concern those who prefer to keep their personal affairs private. Probate avoidance is one of the primary reasons why many people choose to create revocable living trusts in conjunction with their will. Formal requirements for wills vary from state to state. However, there are some general similarities among the states. For a will to be valid, the testator needs to be both a legal adult and mentally competent. Mental competence, or being of sound mind, requires that the testator has a full grasp of the will's significance. This includes understanding the nature and extent of their possessions and knowing how the will allocates these possessions after their passing. In most instances, wills need to be in writing to be considered valid. While some states recognize holographic wills, those handwritten by the testator and not witnessed, this type of will comes with legal risks. It's generally safer and more enforceable to have a will that is typed or printed and properly witnessed per the laws of your state. Moreover, for a will to be recognized, it typically needs to be signed by the testator. Most states require that a will be witnessed by at least two individuals who are not beneficiaries of the will. Witnesses must be of legal age and must sign the will in the presence of the testator and ideally in the presence of each other, acknowledging that the testator has declared the document to be their will. Now that we've outlined the basics of what a will is and why it's an important estate planning tool, let's explore some common terminology related to a will. A testator is someone who creates and signs a will, detailing how their assets should be distributed after their death. A beneficiary is a person or entity, such as a charity, designated in a will to receive assets or benefits from the estate. Beneficiaries can be named for specific items, amounts of money, or as recipients of residual estate assets once debts and taxes have been paid and specific bequests or gifts have been distributed. An executor is the person appointed in a will to carry out the instructions contained within it following the testator's passing. Choosing a reliable and trustworthy executor is vital because they play a pivotal role in ensuring the testator's wishes are honored and the estate is settled smoothly. This role includes several key responsibilities such as initiating the probate process, gathering and safeguarding the deceased assets, paying off debts and taxes owed by the estate, and distributing the remaining assets to the beneficiaries as specified in the will. A guardian is someone appointed in a will to take responsibility for minor children if both parents are deceased or unable to care for them. The guardian's role is to provide for the children's welfare, which includes their living situation, healthcare, education, and any other needs. Appointing a guardian in a will is a significant decision that will affect your children's future and well-being, making it essential to choose someone who shares your values and is capable of raising your children according to your wishes. Choosing a guardian is one of the key considerations for most parents in the creation of their wills. Probate is the court-supervised process of authenticating your will and overseeing the distribution of your estate. While often viewed with apprehension, probate serves to validate your will, thereby facilitating the orderly transfer of assets to your beneficiaries. Having a will can simplify this process, ensuring your estate is settled according to your specified terms. Intestate or intestacy refers to the condition of dying without a valid will. Intestacy laws are state laws that dictate how your assets will be distributed if you die without a will. These laws vary by state, but generally prioritize spouses, children, and other close relatives. A codicil is a legal document that modifies, deletes, or adds to the content of an existing will. Instead of drafting a new will, a codicil can be used to make minor changes, provided it is executed with the same formalities as a will. You can revoke or amend your will at any time for any reason. You may also revoke your old will by executing a new will. Your will remains valid until you revoke it or create a new one. While I always recommend speaking with an attorney for complex or highly personal situations, an attorney isn't always necessary. For many people, online platforms are a smart way to create legal documents affordably and efficiently. That's why I partnered with trusted names like Trust & Will, Nolo, LegalZoom, and Rocket Lawyer to make estate planning more accessible. You'll find those affiliate links below, and using them helps support this channel at no extra cost to you. These online tools allow you to create essential legal documents from home, quickly, affordably, and on your schedule. Take control of your future. Start creating your will today.